All right, here we go. Welcome to week 7, assistance of counsel. We'll blast through this one like last week. I'm sure you're saying yay, 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 yes. We're going to blast through this and go through it all one at a time, okay? I am in Texas, okay? Had to fly out here, take care of some stuff, but okay, enough about me. Let's move on. We're talking about the Sixth Amendment and the U.S. Constitution, as well as the laws of the states, including the provisions entitling an accused to be confronted with a witness for prosecution. All right? So I have on the book there, page 175 states what? So I want you to read that page, first assignment, right? Right out of the get-go, and tell me what your understanding of the conviction of abstasia talks about, right? And how you are allowed to confront everybody of the prosecution. Disruption of the trial, what does that mean under Illinois versus Allen, is what happens when an individual disrupts the trial. Wait, I think we already talked about this, didn't we? Oh, no, this is another one here. Oh, you know why? This picture here is from the other slide, I think, on the other module, right? But look at this guy. Duct tape on his face. Seriously, duct tape on his face. You gotta love that, all right? So at the disruption of the trial, at least 3 constitutional permissible ways for a trial to handle basically this big word here, obstruction. How do you say this word here? Let me hold on and make sure I get it right. Here we go, obstreperous. There you go. That's how you learn. Out of control, cocky, can't control the individual. So when the judge comes across an individual like that who can't contain himself in the courtroom, they're allowed to bind and gag him, thereby keeping him present in the courtroom because they have the right to be present during any evidence against him. So they have the right to be present against any evidence against him, and that would make sense. So here are the people bound and gagged. Which, again, what happened to these people, right? You can cite an individual for contempt of court and take him out of the courtroom if it becomes so bad and bring him back on when he's going to conduct himself in a proper manner. So there you have that. Voluntary absence from the trial. You don't have to be at your trial if you don't want to, but your attorney is going to say you better be there, right? So under the Allen decision, definitely establishes that a trial can take place or could take place in absence of the defendant, all right, when he or she becomes so disruptive that they can remove them from the courtroom if necessary under Curtin versus United States. Also, there was one female on the Arias case. She was so doped up in the case that she is just sitting at the defendant's table and she is just like looped out of her mind. She basically was there because they don't want to remove her because they have a right to be there, but they had her so doped up because she couldn't take what was going on. So, right to counsel. Everybody's got a right to have an attorney under the Sixth Amendment of the Constitution. In all criminal prosecutions, the accused shall have the right to assistance of counsel of his defense and providing the accused with a counsel under Powell versus Alabama. Okay? So, I will go to the next slide here, and I will have you guys do this assignment. So, under the waiver of a counsel under Ferretta versus California, defendants have the constitutional right to self-representation, all right? So what I want you to do under this assignment here is find a court case where the defendant represented himself. So under Google, I want you guys to find under Google where the defendant represented himself at trial. And there's some high-profile cases where the defendant actually did represent himself at trial, and a lot of perverts, the sexual perverts, can't stand those guys. Worst case people of criminals on the earth love to make sure their case goes to jury. Loves for the jury to hear all this stuff because they get to relive the crime again and have access to all the pictures and all this great stuff because whatever the attorney has, the defendant also has too, so they can get their hands and look at all this stuff as much as they want again too. All right, so here this guy, Dylan Roof, right, went into the prayer service at the Methodist Church, and nobody paid attention to him, and he ended up shooting up everybody, and he represented himself at trial. The defense said he was autistic spectrum, and so the judge explained to me, could you explain that to me? Being labeled autistic is worse than death. Roof replied, because once you got that label, there's no point of living anyway. So anyway, he wanted to represent himself during that time, and it was rejected because he was autistic. So I want you to find a case like this where the person wanted to represent himself or did represent himself, and whether if he didn't represent himself, explain the reason why. Don't just send me the picture, right? I'm giving you an example and I'm telling you what I want in your explanation to me, okay? So you can have this nice little picture like I did, you snip it, and then go from there. Okay, continue on with right for counsel. And the Feretta case stated that in order to represent himself, the accused must knowingly and intelligently waive the right to assistance to counsel. That kind of goes on the same aspect also of that when you're advising him of the Fourth Amendment right, all right? So here on this assignment, stand by counsel on page 187 California Penal Code for murder. Doesn't relate, but it is what it is. Please sum up what that means to knowingly and intelligently waive your rights. Woo! How did I end up way over there? Look at me just flying around the page there. All right? All right. When the right of counsel begins, the court states that when the investigation of a crime shifts from being an investigating case to you have your eyeball on a bad guy, and once you have the eyeball on the bad guy, the accused is entitled to the assistance of counsel, and such assistance could be very hollow if denied until the time of trial. So, meaning when you have focused your investigation, it starts big, right? You get a call of shooting, stabbing, assault, robbery, rape, whatever the case may be, mayhem. You got the actual crime itself. Now the crime, you're like trying to figure out who done it. And as it gets to this point right here, where it's like, okay, now we're focusing on this guy right here, right? And that's all you have, that guy right there, right? Look at me, look at that, that's it. Then it becomes accusatory because there's nobody else you're focusing on and only the suspect, all right? So once that happens and you advise a person of Miranda rights, they're entitled to counsel. That's why during Miranda, it states that you have the right to have an attorney present. So that's under the Sixth Amendment. That's why it gets to that under the Miranda waiver. All right? So effective counsel, one who has knowledge of the defendant's rights and who is capable of presenting the defense of which a person's accused. So your mom or Uncle Johnny or whoever cannot go. It's like, oh, I'm going to go in and I'm going to be effective counsel. It's got to be somebody who knows what's going on and appointed on your behalf, which I find amazing because you can represent yourself because you're the one that's in jeopardy of losing your freedom. But yet, mommy or Johnny or daddy can't go represent yourself on your behalf because they have to be able to articulate that they know and have knowledge of your rights and everybody's rights involved. Okay? So, counsel is considered ineffective if it is representing the defendant. The counsel fails to meet the standard of competence expected of criminal cases an attorney. Crucial error made under Strickland versus Washington. So I want you to look up Strickland versus Washington. Don't cut and paste it. Tell me what your opinion is of that particular case. All right? Here's my little cartoon here. So you guys can read all about it, figure out if it's funny or not. So the public offender has appointed counsel. Public offender or the appointed counsel. A public defender's function is representing those defendants who cannot afford an attorney for yourself. So if you're living life high in the hog and you can afford your own attorney, you cannot use a public offender to save yourself some money and say you want to use them. These defendants are referred to as indigent persons or indigent defendants. So here's the case law. Look these up. Tell me all about it so you guys can know all about case law. Here's everything you guys learned today. Woo! Look at that. Defendants have the right to present themselves at a trial, but mommy, daddy, or anybody else can't represent them. They can, once the trial is started, the accused may waive his or her rights to be absent during the program of the trial. And here's everything else you learned. All right, good job. 7 weeks in. Hang tough. Work out all the modules. All right, we'll see you guys next week. Take care. Bye-bye. Do the modules. Don't do them Friday night at 11 o'clock. All right, see you guys later. Bye.